This is the What Just Happened series of the Just Security podcast. I'm David Aaron. It's August 25, 2025. In this episode of the What Just Happened series, we're going to talk about the search warrants that were executed late last week at the office and residence of former National Security Advisor John Bolton. Neither I nor my guests have any direct knowledge of the case, so anything we say about this case will be based on public reporting. Bear in mind that public reporting about an investigation that's ongoing is going to be incomplete. We know that search warrants were executed at Bolton's home and office, and our guest will talk about what that means. The press has reported that the alleged crimes under investigation involve some kind of mishandling of classified information, and the press has reported that some of the information underlying the search warrants was provided to law enforcement by the Central Intelligence Agency. So what does this tell us, and what should we expect? And is this case different than others, or is there anything unusual about it? My two guests are the exact people you want answering these questions. Mary McCord is the executive director of the Institute for Constitutional Advocacy and Protection and a visiting professor of law at Georgetown University Law Center. At ICAP, Mary leads a team that brings constitutional impact litigation at all levels of the federal and state courts across a wide variety of areas, including First Amendment rights, immigration, criminal justice reform, and combating the rise of private paramilitaries. Mary was the acting Assistant Attorney General for National Security at the U.S. Department of Justice from 2016 to 2017, and Principal Deputy Assistant Attorney General for National Security from 2014 to 2016. Previously, Mary was an assistant U.S. attorney for nearly 20 years at the U.S. Attorney's Office for the District of Columbia. She has extensive experience with the kinds of cases at issue on our episode today. Zach Myers is a partner at McCarter and English in Indianapolis, where he co-leads the cybersecurity practice. Zach recently served as United States Attorney for the Southern District of Indiana, where he also served as an assistant United States Attorney. Zach also served as an AUSA in the District of Maryland. Among Zach's other cases, Zach and I were co-counsel on the prosecution of former government contractor Harold Martin and the investigation that led to the search warrant executed at Mr. Martin's residence and the surrounding curtilage. Until a few years ago, the Martin case was probably the largest and most complex prosecution of unlawful retention of national defense information. Zach, Mary, thank you for being here, and I'm happy to reconnect.
It's good to be here.
Great to see you, Dave. Thanks for having me.
Fantastic. At the beginning, let's just level set for the audience. John Bolton is, of course, one of President Trump's former national security advisors. As national security advisor, he had access to the most sensitive information that our nation possesses. People with security clearances agree to keep classified information secret for their entire lives and to seek government approval before publishing certain material. That's what we call pre-publication review. According to media reports, Mr. Bolton was previously criminally investigated in connection with the publication of his 2020 book about working in the White House, and DOJ sued him civilly for violating his pre-publication review obligation, and that case survived a motion to dismiss before being resolved. President Trump and others in his circle have repeatedly criticized Mr. Bolton in the press, and he in turn has remained a vocal critic of President Trump's policies, including in the opening months of President Trump's second term. President Trump has revoked Mr. Bolton's security clearance and his protective detail. So that's our background. That's the setup for all of this. According to the New York Times, sources are saying that the current investigation is not primarily focused on material that Mr. Bolton used in writing the 2020 book. In an interview on the morning of the execution of the warrants, the vice president said that we are currently in the very early stages of an ongoing investigation. He stated classified documents are certainly part of it, but that he thinks there's a broad concern about Mr. Bolton. And he stated that he had not spoken with the FBI that morning. Now, we don't know if Mr. Bolton committed a crime or what's in the affidavits that were provided to the issuing magistrates or judges. We don't know whether new evidence recently came out to support those affidavits. What we do hear from the New York Times is that there was a flurry of activity at his office, the FBI removed some materials. There was a longer search at his residence, multiple vehicles. Agents left carrying about 6 file boxes, and at least one computer appears to have been seized. Before we jump into what we can infer from all of this and what it might mean, let's just briefly touch on what stage this investigation might be at and what the public does and doesn't know. So we'll start with just the basic search warrant requirements. And Zach, just your average search warrant, can you just briefly, what does it mean to get a search warrant? What does it mean that a search warrant was issued?
So in the federal system, which is different than how it works in a lot of states, a search warrant never happens without the combination of a law enforcement officer who's the affiant, who swears off that the document seeking the search warrant, the affidavit, is truthful and accurate, based on the information that the agency's obtained, but also that a lawyer is involved in shepherding these from the beginning and working hand in hand with law enforcement to submit the application and supporting affidavit to the judge so that the judge can review it to say whether or not they think there's probable cause set forth in that affidavit that there's reason to believe there's going to be evidence of a crime located at a particular place. So it's probable cause is not no standard, it's a significant standard, but it's not what you need for going to trial. And to get to this stage, what it means is that some combination of federal law enforcement officers and Justice Department attorneys, whether at Main Justice or at a U.S. Attorney's Office or both, came together and submitted an application to probably 2 different judges in 2 different jurisdictions. And each of those judges found, based on the information provided by the government, probable cause to believe that evidence of a crime might be found.
And you mentioned 2 different judges. That's because one set of premises was in the District of Columbia, the other was in the District of Maryland. Judges generally issue physical search warrants within their own area of jurisdiction, correct?
That's exactly right.
Great. And Mary, Zach used the word is. The evidence is likely to be found. Can you just talk briefly about staleness and what would be required to overcome that?
Yeah, so, Zach gave the process rundown really well. I would note that the evidence that the affiant is put in the application, that the affidavit in support of the search warrant, needs to show probable cause that there is a crime and probable cause that evidence of that crime will be found at the place to be searched. That means it can't be based on some sort of information from 6 years ago, right? Because then there's no indication that the stuff you're searching for is still going to be in that location. So that is what would be called staleness if the affiant was only talking about information from, some source saw something in his residence 6 years ago. A judge would say, that's too old. How do I know it's still there today? So we have to assume that at least the terms of the affidavit had some sort of fresh indication that evidence in support of a crime would be found in both the Maryland residence and the DC office. I'd note one other thing that's unique about this type of a warrant in a national security related case, which is that the Department of Justice's National Security Division always has a role in national security cases, unlike many, many other federal cases that are brought by the U.S. attorneys around the country without hardly any engagement with what we call Main Justice. But all of the 3 of us know, both from being on the side at the U.S. Attorney's Office and in the National Security Division, that Justice Department binding guidance on U.S. Attorney's offices is that cases involving the mishandling of classified information, cases involving terrorism, cases involving other types of counterintelligence or cyber espionage by a nation state, those all must be approved and coordinated with NSD, the National Security Division. And that includes, generally speaking, the approval of search warrants, including the affidavit in support of that search warrant. So we can assume here that this case was not just somebody in the Maryland U.S. Attorney's Office, somebody in the D.C., that this was probably being directed out of Main Justice, or at least very heavily coordinated with Main Justice.
And let's take that a step farther, right? Because there are several reasons for that coordination requirement. And certainly one of them is, for example, when Zach was an assistant U.S. attorney new to these kinds of cases, Zach, fair to say that the degree of coordination within and outside the Department of Justice came as a slight surprise, maybe change of usual practice.
The national security world in the Department of Justice is, I won't say Alice in Wonderland, but it is very different from regular criminal cases. And one of the things that both you and Mary just touched on is really the core of that. It's maybe both the cause or the reason, is National Security Division has approval authorities, review authorities, and kind of the sole leadership role in certain types of things that you just can't do as a U.S. attorney or an assistant U.S. attorney without DOJ and national security cases, and especially with anything involving classified documents. And which serves a lot of important policy purposes. I mean, AUSA, even one focused on cybercrime and national security, might work on 20, 30 different types of cases in a year, but NSD has the National Security Division of Main Justice has people who focus really on the subject matter and on the particular statutes that are difficult and the procedural things that are difficult to really master if you're not getting reps on those statutes all the time, but also for the relationships with in a counterintelligence and counterespionage matter, the intelligence community does not want to, it probably doesn't make sense for the intelligence community to deal with 93 different U.S. attorneys' offices. As much as they might want to talk to Zach and enjoy hanging out with Zach, the fact matters they really want to talk to Dave, because Dave, Mary, the people at Main Justice who deal with them all the time, end up being that coordination point when you've got information that's allegedly owned by some component of the intelligence community. And for logistical reasons, legal reasons, working through the SEPA stuff, which I'm sure we'll talk about, you need that centralized coordination between the prosecutors and investigators, but also the intelligence community.
And Mary, in that regard, and thank you, Zach, you made at least two categories of very good points there. On the substantive aspect of NSD's coordination with the intelligence community, can you just at a high level describe some of the interest that the intelligence community might have even at this early stage?
Well, particularly, again, all we know is public reporting, but particularly in a case, assuming the public reporting is correct, that involves classified information, national defense information, that is information that is, owned by, I think Zach used the words, one of the intelligence community partners, right? So that's one of the departments or agencies. CIA has been mentioned here based on public reporting. They're the ones with the equity. If they accumulated the information using their authorities, then they get to weigh in on whether that ever gets used in a criminal prosecution. And historically, intelligence agencies, their mission is not at all the same as the mission of prosecutors in building a criminal case and prosecuting a criminal case. Our intelligence agency's mission is really to protect the national security of the United States and all U.S. persons and protect our secrets. And that could involve and oftentimes does involve long-term intelligence investigations to understand trends, motives, operational tactics, tradecraft, as they call it in the business, of our adversaries. And that means that if you end up using intelligence information in building a criminal case, some part of that is going to have to be disclosed, right? The defendant has a right to know where the evidence came from, how it was obtained, and that can expose sources and methods. It can expose an open investigation that involves adversaries in ways that our intelligence community very much does not want to make that subject to, public scrutiny. Well, it's not even about scrutiny. They just don't want to divulge it to the public because they want to continue their ongoing investigation. So it's a real sort of dance between DOJ prosecutors and the intelligence agencies when prosecutors really think that something is significant enough and injurious enough to national security and that accountability through criminal prosecution is necessary. And there's oftentimes an inverse relationship between the significance of the national defense information or classified information at issue in a case. And by significance, I mean how damaging to national security it would be if the US government actually admitted in a criminal case, yes, this is real information. There's a inverse relationship between that significance and the likelihood of criminal prosecution. Because if it would be gravely injurious to national security just to even confirm the realness of the information, which you would have to do in a prosecution, our intelligence community will sometimes just say, no, DOJ, you can't bring that case because we will not go into court and confirm this information. And sometimes there are red lines, and you all probably experienced it in your prosecution, and we'll work. And when I was at NSD, sometimes, we're the liaisons between the intelligence community and the rest of the prosecution team. Like, are there things we could say? We will protect this, this, and this. We will use the Classified Information Procedures Act, right, to protect as much as possible. And the intelligence community will say, okay, but if it gets to a point where the judge says you're going to have to disclose X, that's it for us. And the prosecutors sometimes say, okay, that's the red line. And if that were to happen, we recognize we would have to dismiss the case. So it's a very different, as Zach said, it's a very different world when you're prosecuting a national security case than other types of criminal cases.
Thank you. And I'll just make the obvious point that when we talk about disclosing to the public includes adversary nation state intelligence agencies, right? And these are people who specialize in extracting meaning that may not be immediately apparent from every data point that they can get their hands on. And so what might seem obvious or innocuous or not to have clear meaning to a regular member of the public could be extremely useful to an adversary intelligence service and therefore highly damaging to U.S. national security. All right. So that's what's different about some of what's different about a national security case. Just talk a little bit more about what's not different here, right? One factor when a search warrant is executed is usually law enforcement will provide a copy of the warrant itself to the resident or owner of premises being searched, but they won't explain how they got the search warrant, what the basis of it was. They don't publicly disclose the affidavit, the sworn declaration of facts underlying that search warrant. Agree that that's normal in the everyday course of normal,
or even give it to the target, right? Not before any indictment or charges. Usually it's not only not made public, it's not provided. When you leave the residence, you show them the search warrant, you leave the search warrant, but not the affidavit in support of the search warrant. That's right.
And the warrant doesn't say, we were here because we believe that this guy did this thing and he's guilty. It just says, we're authorized to search in this location and seize these things, and that's it. And you draft it intentionally in a way knowing that document is going to be overt earlier than maybe your whole investigation. You're really thoughtful in hopefully crafting the terms of the search warrant paperwork to ensure that you're not revealing more than you need to, but that you're also getting all the legal authority that you need to conduct your investigation appropriately. Because this is sort of moving into, as we say, an overt stage of an investigation. There's all sorts of things the government can do in the course of investigation, and a national security investigation, assuredly has done and has to do to get a buy-in from partner agencies, like we talked about. But to do things like get subpoenas for bank records or electronic account records, or even search warrants of things held at email companies or cloud computing or something like that, before an agent shows up at someone's house with that search warrant, like, oh, now I know that law enforcement is after me, whether you might have believed it or not. You thought that might be happening, now it is for sure. And so there's just a demarcation line that is crossed in an investigation when something becomes overt. And that's why in a lot of legal process we'll say we need to maintain certain types of secrecy to prevent flight or destruction of evidence or tampering with witnesses and those sorts of things. But it's even different. It's even more difficult in a national security matter, because it may well be that the information itself used to get in the door to get the search warrant itself might be classified, because sometimes you have to use classified information to explain to a judge why you believe something related to classified information might be found. And there are procedures for that, to get a search warrant that the affidavit itself, portions or all of it, is classified. And that adds potentially delay and complexity and layers of review, but it's a tool that the government has because the point of these investigations is supposed to be to protect national security information and the national security of the country.
Can I add another point here on this, Dave? Just because over the weekend I've heard, seen various people express some confusion about what type of warrant this was because they hear national security, they think of FISA, right? The Foreign Intelligence Surveillance Act. And I've had a few people say, was this a FISA warrant? No, this is a straight up search warrant, right? This is a search warrant that goes in front of a regular judge. It's not for surveillance. This is literally just to search these two premises. And we've already talked about what would have to be alleged. A FISA warrant is based on a different kind of probable cause. It's based on probable cause that someone is acting as an agent of a foreign power, if it's actually going to be directed potentially at a US person. And that requires other types of criteria and that requires those applications to go in front of a FISA court judge, which is an Article 3 judge, just like all of our federal judges around the country in the different federal jurisdictions, but they are assigned for temporary multi-year periods to the Foreign Intelligence Surveillance Court, and they take turns looking at applications for FISA warrants. And there are various different types of FISA warrants, but it's a completely different procedure, and that's not what we're talking about here when we talk about the search warrants that were executed at John Bolton's residence and his office.
It's a great point. And while there, ever since the aftermath of the Aldrich Ames case, there has been a provision under FISA for physical premises search warrants. Those are classified and they're executed in a probably less public way.
That's right.
The FBI is not going to show up at someone's house and say, we have a warrant from the FISA court. They would have just committed a violation of Section 793. They would have just disclosed classified information by revealing the existence of a FISA search warrant. So it's a great point. This is a criminal investigation of potentially a national security crime. And so that's why it's following, as far as we can tell, some of the standard procedures of a non-public affidavit. We have probably magistrate judges issuing these warrants in, courts that are within the district where the warrants were executed. So there are some things that are different, not necessarily about the warrants themselves, not necessarily about the judges or the affidavits. I'd say it's not that frequent to have the FBI director tweeting about the execution of a search warrant or having the vice president or president being interviewed about a search warrant. Legally, what kinds of impacts, either as a pure matter of law or just a matter of how the public views a criminal proceeding, what impact can that kind of high level off the docket communication about a case potentially have?
Nothing good from a former prosecutor. I'll tell you that regardless of sort of the administration, when you're prosecuting, particularly these high stakes, complex cases, you want to try to control everything that you can in a very chaotic, sort of situation, and having to respond to, react to actions touching on your investigation or prosecution that might be imputed to you and the government, whether you and the actual prosecution team have anything to do with it or not. You don't want, as an AUSA, you probably often don't even want your boss, the U.S. attorney, talking about a case publicly, or certainly not in a way that's unhelpful, let alone having leadership at the top levels of a federal law enforcement agency or even outside of the law enforcement sort of side of things. I know there's been some discussion about this, but at least in the time that I came up to the Department of Justice, there was a very seriously enforced ever since the Watergate fallout, demarcation between the Justice Department and especially on the national security side and the White House. And to have the people from outside of DOJ or the FBI interviewed about commenting on an ongoing investigation that hasn't even led to charges yet is unprecedented in at least since the 70s, to my knowledge. I know we frequently say, this seems unusual. Like, I've never heard of something like this. I'm not the most experienced person on this call here, but I think that as a prosecutor or an agent working on this case, I wouldn't want someone who isn't fully briefed on everything, understand the nuances, understanding those red lines that you might have talked about with the other agencies. It's just it is taking something that's already very difficult to do, and it just makes it so much harder when you've got folks outside of the tent in some ways, who are doing and saying things publicly that can complicate your case in court or complicate your case in front of the jury. And and especially when you get into areas where there could be accusations of politicization, and then you might be dealing in front of a judge or a jury who's hostile to what you're trying to do in your prosecution, thinking that it is not really about enforcing the law, but it's about some inappropriate means.
Yeah, and it can have real world consequences in court too, in terms of legal motions. I mean, there are motions that can be brought to dismiss a case outright for vindictive prosecution, particularly in a case where, at least as we know, based on your intro here and public reporting and things that most of us who are following discussions about some of our international relations, we know that John Bolton has very recently spoken out in opposition to some of the ways that President Trump has been handling the discussions with Vladimir Putin. And then you see an overt search executed right after that at least raises the specter of politicization, as you said, Zach, but also potentially retaliation for exercising First Amendment rights. John Bolton, of course, has a right to speak about what he thinks of these negotiations, if you can call them negotiations, these discussions between President Trump and President Putin. So it can, when you then have statements being made out of the White House about an ongoing investigation, that just sort of leads to that. It could also raise due process issues, because essentially you've got high-level political appointees, and sometimes in some cases the vice president or president himself, talking about someone who's the subject of an investigation but has not been indicted or charged. And that is, can really have the effect of smearing someone with, a presumption of guilt before a chance to prove innocence. And that's why in the Department of Justice, my entire career there, and I suspect both of you as well, you did not do that, right? If you were going to speak, you were just going to give sort of the facts of what's out there. If it was an overt search warrant, yes, we executed a search warrant, but you're not going to make other statements that would suggest wrongdoing on the part or suggest knowledge of something else on the part of the person being investigated, because that can raise real due process concerns. So, I think we have the perception issue, which, like you said, Zach, and this is something that's just been so important to me, after Watergate, the Department of Justice and the White House recognized that they did not want the American people to think that the Department of Justice was being used for political purposes, its vast powers over criminal investigations. And that's why, starting immediately after Watergate, we had these no context policies. And that's a policy that the Attorney General, in fact, Trump's Attorney General in his first administration, conformed to a policy that says prosecutors will not communicate directly with the White House or those within the executive office of the president about their criminal investigations. And we had the White House counsel, every administration, also issuing a policy saying White House officials will not ask Department of Justice for information about ongoing investigations or suggest investigations. And so there are some exceptions to that. I mean, if DOJ through the FBI is going to try to bring a terrorist back to the United States for prosecution, the White House kind of wants to know that in advance. You can sort of understand why. So there's certain exceptions, but it's not about sort of like keeping the White House apprised of day-to-day goings on in criminal investigation, and certainly not about the White House directing things. Yet under this administration, we've had statements coming straight out of the White House that certainly do suggest knowledge of this investigation. I mean, I know President Trump said he was not aware of it, but that he would be getting a briefing. J.D. Vance said something very different than that certainly suggested awareness. So we're just in a really different place, both from a perception, and then, of course, there's the legal ramifications in your case if you're the prosecutor.
Exactly.
one legal thing I would follow up just very briefly on with Mary is not only are there those DOJ regulations and policies and norms back when we talked about norms, but the prosecutors or attorneys, working, as part of a prosecution team, have a special ethical obligation on top of any other attorney, where prosecutors are prohibited from entering into sort of the public sphere information about a criminal case that's not public, because we have all of this ability to gather information, secretly for important reasons. But a defendant can't defend himself, especially if they're not even, or herself, especially if they're not even in court yet. And so prosecutors are not supposed to reveal this information because it might taint the jury, because it might, go after someone who has no chance to defend themselves. But prosecutors are supposed to represent everyone, not just the government. You're upholding the rights of everyone, including the defendant. And so if a prosecutor is involved in or signing off on extrajudicial statements about the content of a investigation, the government's just views of someone, being a very bad criminal, so like there's it's not just like not a good idea to do. It can be a violation of your professional responsibilities as an attorney, depending on what exactly you say.
So broad set of potential impacts of deviating from that traditional rule. And just note that rule exists in part to kind of offset the superior investigative power of the government. There are limitations put on the government to compensate for its greater authority. We'll stick on the topics of consequences, because if this is indeed a case of unlawful retention of national defense information or classified information, that is different from a case of unlawful disclosure, right? Under the Espionage Act, there's espionage, there's full-on spying, taking classified information and giving it to a foreign government. There is taking classified information or national defense information and giving it to someone who's not part of a foreign government but doesn't have the legal right to have it. For example, the media. That would be a leak case. And then there are cases involving retention, just taking the information from where it is supposed to be, keeping it to where it is not supposed to be, based on your training experience. Why does the government care so much about retention cases? I'm sure you each have perspectives on that. Mary, I'll start with you. Where does your mind go when you hear of a retention case?
So if you're talking about pure retention, not transferring it to the media like a leak case, certainly not transferring it to, one of our adversaries, but just keeping it. Like you've got a penchant for saving things and you like to bring them home and you like to put them in your drawer. That's not a secure location, right? Classified information. And boy, I lived this life for a while. Like I worked in a SCIF, a sensitive compartmentalized information facility. My office was in the SCIF. Then I even had safes within my office in the SCIF. And the SCIF means it's like working in a safe. You have to go through a whole combination lock to even get into my office. And then again, some materials that were top secret or even higher had to be in another safe within what is already a safe. Well, at your home, in your bureau or in your desk, in your office, that is not a secure location. So even though a person who retains information might not have any evil intent, if someone of our adversaries were to know, or someone working for one were to get the inkling that that information was within these premises, they might have an incentive to obtain it. And in fact, this was one of the concerns about so many classified documents being at Mar-a-Lago. This is a place that is open to the public, that many foreign nationals have visited. And at least based on the evidence that came to light through different government filings over the course of that attempted prosecution of Donald Trump and two other people, these things were just in boxes in a basement room. They weren't behind us. They weren't in a safe. They weren't in a skiff, and there's vulnerabilities there. So even before you're thinking about, anybody who transfers it or puts it into the hands of others, there's just a danger to that. And I can tell you from my own experience, when I was at NSD and almost everything I was working with was classified, the only thing I could bring home with me was things at the lowest level, secret level, and I had to keep that in a safe within my house behind a dead-bolted door and only take it out when I was looking at it. But I could not bring home top secret. I could not bring home the levels above the top secret. I had to go to my office, which is why I worked till about 11 or 12 o'clock every single night, because all of my work involved such highly classified information. And that's how seriously the intelligence community takes the protection of that information.
And I'll just do a quick public service announcement for anyone currently working with classified information. Mary had specific permission based on her position in the government to take that material home to an authorized location. Most of you out there working in secure jobs or in secure locations do not have that permission. So just bear that in mind, that even
that safe was installed by national security people, the deadbolt. And then when I brought it home, I brought it in a locked bag and had to keep it in a locked bag and did not go anywhere between my office and home with that locked bag. But yes, even that was pretty unusual.
Indeed. And Zach, I mean, when it comes to these secure facilities, whether in a government building or an approved facility, in a residence, part of the security is preventing access to that information. Part of the security is also accounting for who has been near it, whether visitor log or whatever it might be, whether security measures have been breached. There might be evidence tamper. I mean, can you speak to that? Like, in addition to it's just not allowed to be there, what's the harm of keeping classified information where it's not supposed to be?
So there are a number of different harms, which is why when you get indoctrinated into this national security world, it is beaten into you at fear of prosecution. That if you mess this up without any intent to harm the country or to help its adversaries, you could go, and people have gone, to federal prison, because in exchange for getting access to and being able to work on these, important and interesting and meaningful things, you give up your ability to say, oops, sorry, I took my work home, it's too bad, so sad. Like, no, you could go to prison for that. And the reason is, you and Mary both touched on, you lose accountability for, we go through all of these procedures, and having been involved in kind of the building stages of some of these secure facilities for a while, it is not cheap. What the government puts into, and the amount of money that they invest and thought and procedure they invest into protecting classified information, that's not just because we in the government enjoy these things. It's because protecting the sources of this information, the methods that are used to gather it, information, some of which might not even belong to the United States. It might be entrusted to us from foreign intelligence partners. And there's just so much harm that can be done. That's why, in fact, it's exceedingly grave harm is what it's defined in law if top secret information goes somewhere it should not be. And so we design all these processes, all these clearances, all these markings on documents, these places where it's allowed to go and not allowed to go. Because even if someone isn't going all the way to, I'm going to sell this, to an adversary government, just by us no longer being able to account for who had access to that, it limits the government's ability to know that only people with a clearance and a need to know that information have been around it. It hurts our ability to know where everything is. It hurts our ability to follow our declassification practices and procedures. All of this accounting things is not it's not just paperwork, and it's not just there's too much government bureaucracy. That's why during the first Trump administration, the Congress and the president recognized that what had been thrown around as mishandling of classified information was actually a really big deal, and they changed that statute and turned it into a felony, from a misdemeanor to a felony with a 5-year statutory maximum, because it's so much easier now to get large quantities of information, as Dave and I well know, at high volume and speed, and massive amounts of harmful information could just be so easily removed. And so protecting it is so important. And even if you don't think you're doing anything wrong, you don't necessarily know the harm that's caused just by having this information outside of a secure space. You don't know that someone else might have not have gotten into that house of yours that you thought was secure and looked at this information and done bad things. And we'll never know because you took it outside of where it should be. So whether it's, but also it may well be that the government believes or even can some ways prove that you did more than just take stuff and keep it. But for those reasons that we've talked about, because in a national security case, just like any case, you're asking, can the government should do this? And should the government do this? And those equities are just weighed differently in a national security case, because in a bank robbery, you're not thinking about, well, what's the harm to the country if I bring this bank robbery prosecution? But it may be that the government says, you know what, we can bring this as a retention case. We can put the facts in the public that this person removed who had access and willfully retained it. But the risk to some government equity or another of escalating that to a disclosure case, to saying this person gave it to someone else or intended to give it to someone else, the risk there might be too high for the government or the owner of the information to bear. And so what might appear on its face to be a retention case might in fact have great evidence of disclosure of intended distribution, what have you. But for a variety of reasons, the government might decide we're going to stop at retention. And so, taking away from the government the ability to, go after you just for retaining, takes away ability to have accountability even when the harm is too great to bring a larger case.
Good points indeed. And for anyone interested in the show notes, I think we're going to have the letter that was filed by Admiral Rogers when he was the NSA director, just talking a little more about the cost of not knowing who has accessed classified information. There might be programs that have to be terminated, technologies that have to be abandoned, just because the government can no longer be certain that they remain secure. So just the fact of classified information leaving where it's supposed to be, that can be its own costs. Of course, if someone takes it and keeps it somewhere, you don't know what they've done with it or what they intend to do it. Well, thank you both very much. I just want to talk very briefly, and we'll wrap this up thinking about what does it mean. You touched on this already a little bit before, but what does it mean that the government went ahead and took this overt step, and what would the next steps be? What are we looking for, as this case develops, or as any case develops where there's this type of investigative activity? Mary, let's start with you.
Sure. As I think Zach indicated, by the time you take an overt step like a search warrant, you want to have made sure, if you're the investigator, that you've done other things that you needed to do in secret, because once you take this overt step, people know you're investigating someone. And so to the extent that they're like, let's not even take the Bolton case, just like take in general, people who might have been working with the target are thinking, oh, should I get rid of certain evidence, right? Should I delete my email accounts? Should I do this or that or the other thing, right? Should I actually get rid of these documents that I have, in my desk in my home? And so that's why the step usually comes toward the end. It's not because there's some rule that says you have to do every other thing first before you do a search warrant. I mean, if you've got the evidence to support probable cause for a search, you can seek it earlier. But as a matter of just good practice, if you're trying to keep your investigation under wraps, you don't do that until later on in the process. And that's sort of interesting in this case, because we're not even that far into this administration, at least based on public reporting. There was no criminal investigation going on at the time this administration took office. So it would be something rather rapid to get to, and particularly because for all the reasons we've talked about already for almost an hour, I mean, these are complex things and they require lots of discussions with our intelligence community, equity holders, and things like that. And so this is fairly fast to get to the point of a search warrant, unless there was something that was really dramatic that happened and needed to move more quickly for national security purposes, which we haven't necessarily seen those indications. So, this could fizzle out and no charges come of it, and this is the end of it. It could be that there'll be other overt steps that are taken, or it could be the next thing we hear is that there's some sort of charge brought through an indictment or through an information. A misdemeanor could be charged through an information. An indictment, of course, would require a grand jury to actually vote to indict. And I should say that to do an investigation does require opening a grand jury investigation. It's not like the administration can just do a bunch of stuff on its own and then charge somebody for felonies. You would have to have opened an investigation. If you're going to get any subpoenas, you would have had to have opened an investigation in front of a grand jury and those types of things. So, we will see whether there are any charges that come from this, or whether this was something that's not going to result in that. And we will also see if there are charges. We can anticipate many defenses that John Bolton would bring, depending on what those charges are.
Thank you. Zach, any closing thoughts on your end about what may come next?
Well, I think at some point prosecutors would roll their eyes at me when I again, talked about Justice Jackson. But the former Attorney General and later Supreme Court Justice Robert Jackson gave a really important talk called The Federal Prosecutor back in the 40s about the importance of apolitical, divorced from the day-to-day partisanship prosecution from the Justice Department, and how the women and men entrusted with the power of the public are this ultimate check of what could be a terrifyingly abusable set of authorities if people chose to do so. But I think that those of us who've done these cases understand that nothing happens in terms of something going before a grand jury, something getting presented to a judge, agents arriving at a location and removing information, or even charges being brought, that a top executive of an agency or even of the government doesn't just like say something, all those happen. That requires individuals who hopefully are trained and who've sworn an oath to the Constitution and to follow the law and to follow the practices and policies and regulations of the various agencies they work with. That there are people who used to be or who are in the jobs that the three of us used to have, where they have their own independent professional obligations and ethical and hopefully moral obligations to look at everything they're doing and saying, do I have the legal and factual support to be taking this next step that I'm choosing to take? And is this the right thing to do? Which ultimately is what you should be asking yourself as a prosecutor every day. Is this the right thing to do? And if it is, to do it and do it the right way and do it as best you can. But if it's not, put your hand up and say, no, I can't do that. That's the wrong thing to do. But that calculus is different at every stage of an investigation, is sort of what we're getting at. Because the legal standard you have to meet, the impacts, although real, on a person of executing a search warrant, even in an overt fashion, versus bringing a charge that imperils their liberty. The standards are different. What the government it needs to prove is different. I think your ability to walk away and say, okay, we're not going to do this is different. So I guess the bottom line I would just get to is that, I continue to believe in the career individuals who make up the vast majority of the Justice Department. And I hope that everyone who, is working on this and other matters is, taking to heart, everything that Justice Jackson said about the obligations of a federal prosecutor, or really any prosecutor, to do the right thing with the enormous power that's been entrusted to them by the public.
And I would just say, under extraordinary circumstances, because we do know there is a lot of pressure from political actors to go after the president's political enemies. We've seen that, the targeting of Chris Krebs, the targeting of Miles Taylor. There could be legit criminal investigations. We don't know for sure. We've also seen many career DOJ who have left because they did feel pressured to do things that they didn't think they could do in good faith. We had Danielle Sassoon in the U.S. Attorney's Office in Manhattan, right? We had a number of the public integrity prosecutors within Maine Justice leave. We had the chief of the criminal division, my old position in the U.S. Attorney's Office in D.C. leave. We've had one of the immigration attorneys who, was actually forced out for being candid with the court. So I think all of us understand the extraordinary pressure that some of the career people are under, and that's why everything Zach said is just so important. And all of us will stand with the ethical prosecutors and investigators who do their job and do it responsibly and with everything that Justice Jackson ever said about the job of a prosecutor.
Indeed. And we will keep an eye on this case. So far, what we have is 2 search warrants sought by the government, issued by judges in a separate branch. And we'll see where this goes as there are developments. I hope the 2 of you will join us. We can have all kinds of conversations about the Espionage Act and the Classified Information Procedures Act, and it'll be just like old times. So thank you both very much, and appreciate your time. Hope to see you again soon.
Thanks,
Absolutely. Thank you, Dave. Thank you, Mary.
Thanks, Zach.
This episode was hosted by me, David Aaron, and produced by Isaac Rubenstein. Special thanks to Mary McCord and Zach Myers. You can read all of Just Security's coverage of national security law and policy developments on our website. If you enjoyed this episode, please give us a 5-star rating on Apple Podcasts or wherever you listen. Thank you.